Okay. AJ?
You may proceed, Judge.
Yeah, I think we can start. No, we can start. Am I audible? Is everything fine?
Perfectly in order. You may proceed.
All right. Good afternoon, everyone, and Happy New Year. Compliments of the New Year. As you are aware, the South African Bar Association hosts the afternoon programs, Thursday afternoon programs. So today we are going to start with our first speaker of the year, and then I'm going to introduce the speaker to you. And then the speaker is going to be addressing the topic that is going to be presented today. After completing his articles with Adams and Adams, David served as a public prosecutor and a secretary, and a public prosecutor and a secretary at the DOG Advisory Committee on Non-Racial Area Measures. In 1993, he joined the South African Music Rights Organization, SAMRO, as head of legal and broadcasting before joining the South African Trade Association of Recording Companies, RISA, ultimately serving as its COO from 2003. In his capacity, David was instrumental in creation of SAMPRA as a fully functional collective society. He served as the CEO of SAMPRA before he was called to join the Johannesburg Bar. David has contributed articles to Accounting SA, as well as a chapter on the music rights in Wat Sê die Prokureur, a publication based on eponymous SABC radio programs in which he frequently participated. David has also presented lectures on copyrights at the Wits Law School for LLM students and the University of Pretoria Drama Department for undergraduates, while frequenting local and international conferences as a presenter on the topic of copyrights development in South Africa. David holds the BLC LLB from University of Pretoria and LLM with distinction from West University. Ladies and gentlemen, allow me to introduce our speaker now today, David, to continue with his presentation. Thank you very much.
Thank you for the friendly introduction. I must apologize for my rather informal attire, but I developed a nosebleed and I have to be as cool as possible. So unfortunately, no tie and long sleeve shirts for me at this point in time. If I can just kick off, basically I'm going to cover where we get our copyright legislation from, then what the copyright landscape is like in South Africa. Then I'm going to look at the amendment bills that are currently in the pipeline and have been in the pipeline for quite some time. And then I'm going to deal with some practical issues in dealing with copyright legislation that one must be aware of. So if we start with the history, in all the British colonies, the British Copyright Act of 1911 would have applied. That was the case then also in South Africa, until we had our own Copyright Act in 1965, which was then substituted with the Copyright Act of 1978. Now, most British colonies, if not all of them, would typically follow British legislation. So our legislation looks remarkably similar to legislation from countries like Canada, Australia, and the former British colonies in the rest of Africa. So there's a lot in common that one would find there. But there's also a common error, which is an assumption that US copyright law applies in all other kind of territories. So that is emphatically not the case, because copyright is determined by territory. So certain copyright provisions will apply in, say, South Africa, and others which may look broadly similar will apply in another country which may not be far away. But they are not necessarily guaranteed to be identical. Now, when it comes to the United States only signed on to certain international copyright treaties relatively late in the day. So things like, for instance, the Berne Convention, which deals with the copyright in literary and musical works, was something which was only ratified by the United States in the past 30 years or so, whereas countries like France, Germany, and even South Africa had ratified the Rome Convention many more decades before that. So it is a common error for people to assume that terminology that applies in the United States also applies elsewhere. The fact that the United States is a major producer of copyright material does not mean that the copyright law of the United States would necessarily apply to those products anywhere else in the world. So where confusion typically comes in is around the term of copyright protection, which in the United States could be as long as 95 years. In South Africa, the longest is 50 years after the death of a composer or an author. Then there's also huge confusion, around the concepts of fair use and fair dealing. Now, fair use is a concept which is unique to the United States. Fair dealing is a concept which finds application in the United Kingdom, South Africa, and elsewhere. However, more about that when we talk about the Copyright Amendment Bill. So always bear in mind that territory and the country where something comes from is relevant to a certain extent, but will not determine the protection in that particular territory. So American works are protected in terms of South African law in South Africa, not American law. Like I mentioned earlier, there are international treaties that apply. However, not all countries have ratified these treaties. So in the case of South Africa has not ratified the Rome Convention or the World Intellectual Property Internet Treaties, which means that we are, or our people don't enjoy the protection of those treaties in other territories. We can look into that a little bit more later. Now, in the South African copyright landscape, there's sometimes a debate about the regulation of industries, specifically the music industry. People will say it's a good thing, they must be regulated. And if they are regulated, then all kinds of abuses won't happen. The question, however, is the CIPC, being the regulatory body, actually equipped to deal with such a function? In this regard, I would like to direct your attention to the case of the CIPC versus IMPRA, that's IMPRA, case number 37475 of 2020, where in a ruling by Acting Judge Ngulwana, he said at the end of the ruling, counsel for IMPRA also intimated that it is troubling for an officer of the court, in brackets, an advocate in the form and shape of the commissioner, close bracket, to advance untruths under oath and suppress material facts in an ex parte application. Then he carries on to say, officials, whether public, private or hybrid, should be reminded that the statutory power does not confer license to bully those over whom they exercise that power. Theirs is the power to serve. Now, this, I think, ties it up neatly, because if there's one thing that I realized early on is that it would be misguided to put your trust in the regulator, to say that the regulator is somehow going to have all these great insights into how your industry should be run. So the first thing that I would like to emphasize is that always be aware of this ruling, because it makes it quite clear that CIPC is not to be taken necessarily at its word on certain rulings that they make. In this particular instance, there was a threat of withdrawing the accreditation of a collecting society called Emperor. There was then a meeting held on a Teams platform where certain questions were posed and they were answered. That meeting was recorded, and subsequent to the meeting, CIPC representatives then claimed that Emperor refused to comply with certain requirements. It was then pointed out to them ultimately in the recording that was made that there was no such thing ever happened, because Emperor was always willing to comply. However, the commissioner of CIPC then put out an affidavit claiming under oath that the people from Emperor were unwilling to comply with the law. Now, that is simply untrue, but because the commissioner of CIPC also had the authority to then withhold or withdraw the accreditation of Emperor, there were serious consequences for holding that position. So it was very disappointing to experience the commissioner of CIPC, who, as you can gather from the ruling, is an advocate of the High Court, and nevertheless, in an ex parte application, simply committed to untruths, if you want to put it as a euphemism. So, in short, I would just like to caution everybody in their dealings with CIPC that it is not necessarily going to be a straight and easy ride when you deal with them. And if you insist on being regulated or an industry being regulated, but the regulator himself doesn't actually play according to his own rules, you have a problem. And I think that one must be aware that these problems do exist. So where this comes up is that there are amendments that are proposed to the Copyright Bill and to the Performance Protection Bill, which go hand in hand with each other. Now, the Department of Trade and Industry started publishing policy papers around changes to the Copyright Act about 10 or more years ago. In this document, it referred to fair use / fair dealing. Now, this is immediately something that should worry one, because fair use and fair dealing is not something which you can just separate with a slash as if they are possibly something similar or the same thing. Fair use is a principle that applies in the United States, which says, amongst other things, that as the owner of a copy or the owner of a, call it a CD, you are entitled to make a backup copy of that CD, no questions asked, as long as you don't abuse it for commercial use otherwise or sell it or something like that. Fair dealing, which is something which you would have found in South Africa, says that you're only able to use a limited part of somebody else's copyright material as long as it doesn't interfere with the normal commercial exploitation of that work. So in the case of fair use, you are entitled to use somebody else's work subject to certain provisions. In the case of fair dealing, you are not entitled to use somebody else's copyright material. Where you can use it, it is subject to very strict guidelines as to what is allowed and what is not. So when the understanding or the level of understanding at the Department of Trade and Industry is at such a level that they don't seem to, or they don't appear to grasp that there is a significant difference between these concepts, it is worrying. Now, various workshops were then held by the Department of Trade and Industry to discuss these bills. At one of these workshops in Kempton Park, the audience was told that people should stop being fixated on typos and rather deal with substantive issues. The problem was that in the subsequent drafts that came out, what had been identified as typos by the Department of Trade and Industry actually then appeared to be intentional changes to the Act. Now, that is a bit worrying also because in one instance, provision was made in the regulations pertaining to collecting societies for 3 different types of collecting societies. In the bill that came out, provision was only made for 2, and that category of collecting society that now disappeared was in fact the very category under which the only 2 collecting societies dealing with performers and record companies could actually exercise their rights. So that simply disappeared in the bill. Now, that was identified as a typo, but it persisted right up to this point in time in whatever other version of the bill they brought out. That just remained absent. So people were not very happy with the approach adopted by the DTI because they never got the sense, and I'm talking about people on both sides of the debate, never felt that DTI was actually listening to them. So there was never a case of DTI saying, okay, if I understand you correctly, this is what you're saying, A, B, C, D, E. And then you could say, yes, that's what I want, that's what I need. And then DTI could respond by saying, well, obviously we can't give you everything that you want. We have to balance certain interests, but that never happened. So it was anybody's guess as to whether any of these submissions were ever listened to. Now, people obviously get rather frustrated when they feel that they're not getting heard. So the bills then did go through both houses of Parliament, but it then sat on the President's desk for about a year. Now, you will know that in terms of the Constitution, the President has to sign the bills or raise his constitutional concerns. He can't just do nothing. But because nothing happened for almost a year, Blind SA, which represents the interest of the visually impaired, then launched proceedings in the Constitutional Court to force the President's hand. So shortly after the proceedings were launched, the President then raised his constitutional concerns, and then the thing was thrown back to Parliament. It is now being considered in Parliament by the various portfolio committees. So it seems at least as if this thing is going to find some form of conclusion in the not too distant future. It is just unfortunate that the approach adopted by the DTI around the Copyright Act appeared to be that we will just throw all these things onto the table and then let the interested parties fight it out amongst themselves as to what may or may not find its way into the bill. Now, that doesn't really assist anybody because how do you know that they've given due consideration to the submissions that have been made? So, for instance, when this thing was at Parliament, I'm told that on one good afternoon, the Portfolio Committee then had to consider something like 1,000 or 1,500 written representations, which they obviously would never have the time to do in the period of a few hours, if that long. So it is unfortunate that it would appear as if this is not something which is taken either seriously by Parliament, because it's seen as entertainment, and entertainment when it comes to musicians and things like that, not necessarily a very serious issue. But the point is that you find that people are getting more and more disgruntled. So instead of trying to carve things up into various categories, I mean, if you put everything onto the table, you have actors, you have musicians, you have that is musicians in the form of performers, you have composers, you have other interests of people like the visually impaired, you've got educational concerns, you've got music, you've got book publishers who feel that the introduction of principles of fair dealing, or fair use rather, is going to mean the end of their industries. So you have all these various parties that are very upset about how things are being dealt with. Now, I would have thought that the best way to deal with it rather is to separate the contentious issues from the non-contentious issues and not throw everything into the same pot. So, for instance, one would have found that there are very few people that would object to the demands made by the visually impaired. It is also definitely not something which is going to have a huge impact on the bottom line of rights holders. So why not rather separate that issue and let's get that through? You've got actors who also have certain rights that they should have for the rebroadcast of their recorded audiovisual materials. So at present, they're not able to actually make money or monetize that kind of usage. So that is not something which is seriously contentious. The contentious issues are those dealing with the fair use, fair dealing aspects. Now, it is something which obviously requires a lot of thinking because it is not a simple matter, and it has a long history. Now, you would realize that you can't simply take something which is of a foreign origin and implant that in South Africa if the jurisprudence and the legal culture doesn't actually provide for it. So you have to tread very carefully about what you want to introduce, and it requires some very careful thought as to what exactly it is that you want to introduce. But I get the sense that most of these issues are dealt with in a rather loose manner, which means that when rights holders want to raise their legitimate concerns, they don't know whether it's actually being taken seriously or not. So that is where we currently stand. It's currently being considered by Parliament again and the portfolio committees, and hopefully one will be able to see some progress there. But anything that happens in the copyright world which is affected by what's in the bills, one would have to proceed with caution if you are going to advise clients about what they should or shouldn't do. I would then like to deal briefly with some basic errors in copyright litigation that I've picked up over the years. Now, for most people, music is just a singular thing. You listen to a song over the radio, but it is obviously something which is made up of various other rights. So a song that you hear over the radio would have a copyright in the composition, but you would also have a copyright in the sound recording. Two separate copyrights which receive separate protection. In the case of the recorded performance, the sound recording, you also would have a performer who receives protection in terms of the Performance Protection Act. So you have to keep these things in mind when you are approached by a client or by your attorney who says that they would like to get some advice on something that's happened here. So the copyright in the composition, the rights that vest in the compositions are pretty much, or look pretty much the same as the copyright in sound recordings. And also they look pretty much the same as the copyright in cinematograph films. So you would have things like the right of reproducing that work, you would have the right of performance in public or public exhibition, and you would have rights of diffusion, and you would have the right of broadcast. So when you enter the field of public performance, broadcast, diffusion, and all these things, you must be very careful, because they may not always mean what you think they mean. So when you talk about a public performance, you will in the first place find that it is not defined in the Act what a public performance is. However, a public performance has been defined over the years through case law as meaning a performance which is taking place outside the domestic circle. So if I go to a restaurant, that is not the domestic circle. If I buy out the entire premises for one evening at a restaurant and I only invite my family, I could legitimately claim that it is the domestic circle. However, if I have a concert at my private residence and I charge entrance fees to people to come and attend my concert, even though it is my private residence, it is a public performance. So what matters is not the nature of the venue, but the nature of the audience. When you talk about a broadcast, there is no such thing as a public broadcast. There is such a thing as just a broadcast by a public broadcaster, but it's not a public broadcast. Broadcast is defined as the transmission of a signal below 3000 gigahertz and also a transmission via satellite. A diffusion is something where you transmit a signal through a physical carrier, like for instance, copper cable, optic fiber, or something like that, whereby you are transmitting a signal. It is like a broadcast, but through a physical carrier. A broadcast is taking place through the ether. So, what you will find is that there are often instances where people rush to the collecting society, if there is one, and say, okay, but they are licensing this, they probably know what they're talking about. Just proceed with caution when you are dealing with a collecting society, because even though I'm not going to suggest that they are anything less than honest, they are also trying to maximize income. So one would have read in the newspapers often about collecting societies and complaints about why they are doing this or that, or that people have not been paid. Now, the one instance where I know for a fact that they are getting things wrong is I've had to advise a client where between Samro and Capasso, dealing with performance rights in compositions and mechanical rights in compositions, purported to license the right of communicating to the public a composition. Now, if you go back to the Act, you'll see that the right of communicating to the public is something which exists in a sound recording, but it doesn't exist for a musical work, a composition. So even though somebody might tell you with seemingly great authority that they hold the rights to license this and that and the next, you would be well advised to actually go and check in the Copyright Act if that right actually even exists in this country. So be very cautious of people claiming to administer rights. First check what the rights are that they claim to administer and if those rights even exist in this country. So just to put you in the picture, the tariffs that are charged by these organizations are all subject to an investigation by the Copyright Tribunal. You are free as a user to raise concerns about the application of a tariff in a discriminatory fashion or an arbitrary fashion, and you can take it to the Copyright Tribunal, and it doesn't have to be something seriously complicated, because the problem that you have with the Copyright Tribunal up to this point is that it hasn't been in session for very long. So there was a case before the Copyright Tribunal in about 1968. I was then when I was at SAMPRO, part of a referral to the Copyright Tribunal in about 2010 and then 2011. Now, those were the second and the third referrals to the Copyright Tribunal after 1968. That means that there's been zero opportunity to build up any jurisprudence or case law or anything around referrals to the Copyright Tribunal. So it is a problem when you don't have that kind of background, and especially if people then, because most people, including everybody participating in this meeting, are probably going to be more comfortable with things that they have dealt with in the past than things that they haven't dealt with in the past. That's kind of obvious. So because this is not something which has featured all that often on our legal landscape, it is the kind of thing that people tend to want to stay away from because they feel out of their comfort zone. So I would just like to say that that is not something that should keep you from getting involved in a Copyright Tribunal referral. There's nothing unique or special about this. It is just another tribunal. So that brings me to another point, and that is there could be a sense of, I don't really want to do copyright because it seems very complicated, or it's like whatever the reason may be. The thing is, it's like a fear of maths or a fear of Latin or something. It is not something to be feared. It is just another aspect or area of the law that you can practice in. So if I look at my practice, I mean, I have an incredible amount of people coming out of the music industry that requires assistance. However, the people coming from the music industry typically don't have money to pay for legal services. So in that sense, then, it is something where you have to proceed with caution if you want to make money out of a copyright practice, because the lots of people who actually require your services probably won't be able to pay for it. That doesn't mean that you can't assist them, just bear that in mind. So there are other people or other interests that would require copyright services that tend to have more money, like, for instance, people involved in computer programs and similar kind of things. So I think that people should dismiss any preconceived notions that they have about copyright being difficult. I've been involved in litigation with many counsel and many attorneys over the years, and it is not as if the great copyright specialists, if there are any, actually gave you a better service. In my experience, the people that did the best were the generalists that was able to bring their expertise in all the other kind of areas of law to copyright. Because if you have a very narrow approach around copyright, which is possible, you are going to miss an incredible amount of things. Also bear in mind that when you go to the big IP firms, they usually have in the same font size patents, trademarks, copyright, and designs, possibly. Now, the fact that the font size is the same doesn't mean that the expertise in that firm is necessarily at the same level. So most of the firms are pretty good as far as patents and trademarks are concerned. But because there is not so much copyright litigation, they are not going to invest huge amounts of money and time into building up a copyright practice. which does leave scope for people to actually zoom in on copyright. But you must know what you're talking about. But a good place to start is obviously studying up on the Copyright Act. You're not going to find everything that you need to know in the Copyright Act, but you'd be surprised at how much people miss when they think that they've read the Copyright Act, but they still don't grasp everything that they should be grasping. So at that point, I would like to ask if there are any questions, because I've now been talking non-stop for the past 40 minutes.
Thank you, Council. Council, my question is with regards to the Copyright Tribunal. Now, specifically, what are the functions of the Copyright Tribunal, and how does one go about lodging a dispute therein?
Thank you for the question. The Copyright Tribunal only has the power to determine how much a royalty should be. It does not have the power to actually enforce that. So it's also another thing that they can consider is the split between the various parties that are entitled to a royalty. So you can say that they can make a ruling that the split is going to be 25, 25, 50 in favor of the following parties, and also that the royalty payable by Shoprite Checkers, for instance, must be 50 Rand per square meter area where the music is rendered audible in their outlets. So that's what they can do. If Shoprite Checkers, and I'm just using this as an example, I'm not saying Shoprite Checkers are not paying, but any party who doesn't pay, you would have to go to the ordinary courts to actually enforce that ruling.
Thank you, Council.
Thank you.
Over to you, Judge Ntambaleni.
If there are any other questions, any other further questions? I think you can proceed with the presentation. If you have any question, you can from the participants, they can raise their hands, and then they can also put the questions on the chat box for them to be attended by David later. Thank you very much.
Thank you. Okay. Let me just think if there was something else that I wanted to specifically raise. Okay, if I can maybe just use some examples which might also trigger some thoughts as to how these things work. Let's use an example of where things feature and who's responsible for the licensing of that. When you have a live concert in Johannesburg City Hall, and they are going to be performing works that are in copyright, which means that the author of the composition has not passed on more than 50 years ago, then you would typically require a license from SAMRO, Southern African Music Rights Organization, who would be able to license their repertoire. If you're going to make use of sound recordings, you would then require a license from either SAMPRA or from IMPRA for the communicating to the public of that sound recording. Now, the pie of sound recording repertoire can only be 100% big, which means that if you have a license from IMPRA and from SAMPRA, it cannot exceed the total cost of what a license would be to cover all their repertoire if they all belong to the same organization. One thing that people seem to not understand is that the licensing of compositions and sound recordings is something which is done on a collective blanket license basis. Now, a blanket license refers to the fact that it covers everything. It doesn't refer to the fact that you are hiding something. So when I give somebody a blanket license, it depends on two things. The first is that you must account to me for what you have played. So you must give me a playlist of what you've played, and then you must pay me the amount calculated as the license fee. Those are the two legs on which a blanket license functions. Now, that is a far more practical way of licensing works than a transactional license, which would imply that you apply up front for a license for the works that you intend to broadcast, for instance, and then I determine how much you have to pay for that, because that would be, from an administrative point of view, a huge burden to actually calculate constantly what is being played and how much must be paid for it. So to deal with things like this on a blanket license basis, collective licensing is the way to proceed. People often think that SAMRO or somebody else receives from SABC every day a certain amount of money for the song that was played 5 minutes ago. It doesn't work that way. So in broad strokes, SABC would account to SAMRO for the works that they have broadcast, and they would then pay them on a percentage of their advertising revenue as defined. So that would mean, in the case of radio, that SABC would pay something like 3.25% of advertising revenue for SAMRO for the use of SAMRO repertoire. SAMRO does not only represent local composers and local music publishers, but also international music publishers, however, and composers, of course. Bear in mind that there must be reciprocal agreements between that territory from which the song originates and SAMRO. It is not something which you can just make up as you go along. A thing which is also misunderstood and exploited sometimes by some collecting societies is to say that, given the fact that recognition of works are based on international treaties, so it is this or that treaty which is entered into between territories, countries, that allows South Africa, for instance, to collect on behalf of another party. This thing is sometimes deliberately abused by some parties who think that they can then themselves actually enter into a bilateral agreement with a collecting society in another country where recognition does not exist, and that you can somehow override the provisions of legislation as it applies between countries. Now, there are examples in copyright where it says that unless the parties agree to something to the contrary, the following principles will apply. So that is, for instance, the case when it comes to mechanical rights in musical works. That's the right of reproducing a composition. The regulations provide that if the parties agree to something different from what the regulations say, then that will apply. But that's fine because you're actually allowed in terms of the regulations to do that. What you are not allowed to do is where the legislation does not provide for something to be negotiated between the parties in the absence of an agreement to the contrary, that the regulations will apply. You can't just then come up with your own reciprocity, so to speak, and say, oh no, that's fine because that's a bilateral agreement between the parties. If it's not allowed in terms of your national legislation, it is not allowed. No exceptions. So that is something that you must be very careful about, because when somebody comes to you and says, I want you to pay this license fee, Well, in the first place, you have to ask, well, what's your repertoire? What works do you represent? And in terms of what do you represent those works? So if somebody comes to me and says, oh yeah, you're playing this and that, and therefore you have to pay me, don't just fall for it. Dig a little bit deeper. Because I've found that some collecting societies actually want to collect for works that are no longer in copyright. I've found that some collecting societies, like I mentioned earlier, want to collect for rights that don't even exist in this country. So it is easy to be deferential to people who appear as if they know more. Do not assume that they know more. Rather assume that you have to ascertain and confirm whether the people actually have the rights, the rights that they claim to have. I'm not saying that all of them are dishonest, but I'm saying that at a low level of administrator, they may not actually want to go and make the effort of determining whether this composer is out of copyright or in copyright. So be on the lookout for all those angles where people are prone to overstate who and what they represent. It is one of the great lies of Hollywood to say, I own the copyright, and that is in fact true, because when you own the copyright, you actually have quite a lot in your back pocket. But having said that, let's say if you look at the typical performer that's going to come knocking on your door, anything which is often stated in the media about artists who are ripped off by record companies. Now, just bear in mind that anecdotal evidence from about a decade ago suggests that 1 out of 10 albums that are released would actually break even. Now, if I'm heading up business affairs at a record company and I'm in charge of drafting contracts, I would definitely draft a contract which would provide for the likelihood of the people signing up to my company to form part of the 90% that are not going to break even, because those are the odds. There's obviously no compelling reason why anybody should part with their money to give you a recording contract. If you want to have yourself recorded, you can obviously pay for it yourself. Having, however, entered into a recording contract, it's obviously important that the record company accounts to you properly like they should. So I represented a very well-known artist a few years ago who had not been accounted to by a very well-known record company for a number of years. And that was on the music publishing side. So eventually what happened was that I managed to get the copyright back from the music publisher for the composer in respect of his most well-known work, because the music publisher failed to account properly for all the income that had been received over the years. In this particular instance, they had simply scanned their contracts onto A4-sized material and stored that in their archives. As a result of that, they actually cut off the sections of the contract that deals with sound recordings, but there was a section that dealt with the payment of royalties. So in that instance, it actually suited us far better to have a contract that was half cut off, because it actually resulted in the performer getting much more money than he would have otherwise. Now, it is something like that that I suppose the people from business affairs at the record company and the music publisher should have picked up, but they didn't even bother. They didn't notice that. So always look very carefully at what you are given. Because, I mean, the dead giveaway was when the paragraphs jumped from 3A to 5E on the next page, then you know that something is missing and it's something that must be followed up. So do not think that the people working at the record company are so extremely clever and clued up about everything. If you do a little bit of research, you may possibly even know more than the people that are supposed to look after the rights of the record company in many instances. So what I'm also then trying to say is, please get involved in your practice in dealing with these kind of issues, because it is not rocket science. It is simply another way in which the people are trying to, let's say, make money, but it's something which is not all that difficult, in all honesty. I've never encountered something which is completely impossible to comprehend. Very few issues that are initially deemed to be copyright issues are actually turn out to be real copyright issues. You will find that most of them actually boil down to interpretation of contracts or law of contract or tax issues or things like that. So very few issues are actually true hard copyright issues. So it is then an intersection of copyright and entertainment law, where you will find that if you're able to advise people on contracts that they enter into with music publishers and record companies, that's business that is really worth doing. And you can also then start learning about the contracts that are issued by the likes of record companies and music publishers. Because one thing that I picked up with people that recently signed with a big record company was that when they approached me through an attorney, of course, was that they said, well, they've got this deal on the table. Well, when you've got a deal on the table from record company A, but you don't have anything else, then that's the best deal that you're ever going to have. So it was only when I was able to get them to approach other record companies and put other alternative deals on the table that one could arrive at the best possible deal for them currently under the circumstances. But always bear in mind, when you feel that somebody is being exploited, first bear in mind that that contract is supposed to cater for the 9 out of 10 entities or individuals that are not successful. Yes, it does happen that I now sign a contract that is catering for the 9 out of 10, and then I turn out to be massively successful. Now, at that point, of course, you feel this is incredibly unfair, because it is. But I mean, but the odds of you being the one that is 1 out of 10 and not the 9 out of the 10 is what it is. So that's why you may find that the initial contract entered into by an artist with a record company, if that artist is successful, is going to look completely different from the contract that they will eventually, or 10 years, 20 years later, sign with somebody else. Also important to realize in this regard is that recording artists have a shelf life. whether you like it or not. So it is usually about the length of one cycle of adolescence is how long the shelf life is of a performing artist. Unless you happen to be Billy Joel, Elton John, the Bee Gees, and a few others. But I mean, you can count them on your two hands. So the normal deal is that people have a shelf life of 6-7 years. So it is important that people in that period already start applying sound business principles and do not wait until they are left with no money only to find out that they've been ripped off by a manager who didn't account to them properly. Okay, I think we've run out of time now, so I don't know if I may have prompted some questions or further questions.
No. Indeed. I think the time is 5 o'clock now, and if there are further questions, we will ask those questions so that David can be able to address them.
Fine.
David, my question, while we are waiting for questions of other participants, is with our local artists relating to the issues pertaining to the royalties that they claim that they don't receive. What is the process that goes into that process? Because you seem to have a lot of experience in dealing with that, and you can see that there's an issue when our local artists pass away, and it's said that they didn't leave anything and they were not getting their money, and issues of that nature.
Yeah. Look, the first thing that you have to ask is, where does this person belong as a member? Is this person a member of this collecting society or that collecting society? So a collecting society is supposed to distribute the monies in the most fair possible way to those individuals whose works have been used. So I can compose 500,000 works and none of them ever get performed or broadcast on radio. Nobody ever plays it. It's just sitting there in a closet. But I've composed 500,000 songs. You could compose something, you could compose a single song which is played non-stop on radio. You are going to earn royalties. I'm not going to earn a single cent, even though I've composed 500,000 songs. So what you find normally is that somebody in that initial phase when they are popular would earn royalties from the likes of SABC or whatever radio station is broadcasting their works. But that popularity then kind of goes down as time goes by. It might pick up again later when there is renewed interest in somebody, but unless you are actually reinventing yourself, and there I would like to refer to the Bee Gees as a prime example. The brothers Gibb started out in the 60s as a pop band, and then in the 70s moved over to disco. Then there was a backlash in the early 80s against disco, and they started composing mainly for other people. And then in their fourth reincarnation, they did another blend or brand of popular music, but not like anything like they did in the 60s. So effectively, they reinvented themselves. And the eldest brother, Barry Gibb, I think just turned 40 at the time of their fourth reinvention. So if you see that the market is moving on, you either have to stick with the market and give them what they want, but there is no special other dispensation whereby people who are performing artists are going to be insulated from being self-employed. I mean, we are all self-employed that participate in this meeting. You know that if you don't go out and constantly make money, times are going to be tough. So if you say, okay, well, I see that people that work in civil service, they retire at 55 or 60 or 65, and I also want to retire, even though I'm at the bar, well, it could be tricky because, I mean, it's not guaranteed that you will have money. So there are reasons why people end up being destitute or poor or dying as paupers, which is a phrase that people are fond of using. And that could be because people have ripped you off. Fine, let's look into that. But it could also be that your expenses consistently exceed your income. Now, you can be a brain surgeon, and if your expenditure consistently exceeds your income, you will die as a pauper. It's not something which is unique to people in the music industry. So one must just retain a bit of perspective on why people are dying as paupers. It's not some sinister plot against people who choose to be musicians. There could be a variety of reasons, and they need to be looked into. But you can't assume that there is somebody that I want to blame. I must find somebody to blame. Maybe you are to blame for the position that you find yourselves in. So in some cases where some record companies have looked into why people died as paupers, specifically in the case of Maglatini, the Gallo record company, if I recall correctly, looked into it and found how much they paid him. But if the money is then spent in a manner which is not going to safeguard a nest egg for your retirement days, you are going to have problems. Now, if you look at the media and the way that artists are portrayed as all being massively successful and driving flashy cars, and if you feel compelled that you must keep up with the Joneses, so to speak, you may find that you are going to run into certain difficulties, financially speaking. And to the extent that you want to blame others then for that, maybe that's true. Maybe they should be blamed. But I would not necessarily think that there are just a finite number of people that you can blame for something like this happening. It is something that you have to investigate in every single instance. It is assumed that when parties are regulated that these things will get better. But like I explained right at the beginning, the regulator himself actually requires regulation in the manner in which he conducts himself. Not because I say so, but because the judge said so. So I think that one must just be cautious about jumping to conclusions about who to blame.
Thank you very much for that explanation, and thank you very much again for your time and for such an informative topic. Our members who can watch the interview at their own leisure. It's recorded, and we again say, David, thank you so much. And when we call in the future, please do come, because this is a broad topic and maybe we might extend it in future dealing with other things. But thank you so much for your time and for teaching us and opening our eyes on many levels. Thank you so much.
It is a pleasure. It's also a lot of information to absorb in one session. So yeah. I'd be more than willing to actually participate again in a similar kind of event, or if people want to contact me, if they are approached by clients and attorneys, I can definitely assist.
Thank you so much, David. We thank you so much for your time, and we will be in touch with you in the future. And for other participants, this interview is available. It's recorded, and then you can watch it in your own leisure. We look forward to having a fruitful relationship with you in future, David. So thank you so much for your time.
Pleasure. Thank you very much.
Thanks.
Okay, thanks. Bye.
Bye.